for joining us. My name is Jen Steinman. I am responsible for Deloitte's sustainability business globally, and we're thrilled to have you with us today. When we think about this climate and more broadly sustainability, it's really a global set of issues that we're facing. And governments, non-government organizations, individuals all have and share responsibility for protecting our planet. And we also believe that businesses have an important role to play in taking action. And so the reason we're here today, we're brought together by a group of organizations that have been collaborating, Deloitte with the Climate Governance Initiative, and based on the work that we've been doing with the World Economic Forum and their group of community of climate governance experts. We're really thrilled to spend this time with you today looking at some of the issues associated with how boards can play a role. And boards have an important role to play here. There's a role around thinking about governance and how one can look at sustainability governance models, looking around corners and helping think about some of the most challenging and intractable issues of our time, such as climate change, looking at and thinking about how companies in general can look at climate change and infuse both sustainability objectives and more broadly cultural changes in an organization. So we look forward to exploring those and many other areas with you today. This is fun.
This alarm has ring out throughout the entire building. The alarm activated on every floor. At this point, building personnel are checking the condition out, and there is no cause for concern. We will notify you as conditions warrant. Once again, we have received a water flow alarm on the 50th floor of this building. The alarm came in on every floor in the building. At this point, building personnel are checking the condition out, and there is no cause for concern. We will notify you further as conditions warrant.
Is this being live streamed, by the way? Yes, yes, everybody give a round of applause. This is great. Excellent, excellent. I think with that, I'm handing it over to. Yes, please, Rob Van Diet. We've been working with the World Economic Forum, and Rob takes responsibility for the First Movers Coalition. We've been enjoying our collaboration, so I'll have you say a few words of welcome, probably better than that announcement.
Yeah, no, thank you, Jen. No, actually, all my comments, what the gentleman just said, were effectively also my comments. So I feel a little bit robbed of my. So yeah, thanks for being here. My name is Rob Van Diet. I'm the head of the First Movers Coalition at the World Economic Forum, but I've also been working very closely with the CGI team and with Deloitte on the Climate Governance Initiative and the work with NEDS, which is interesting for the forum because we traditionally have worked mostly with CEOs, certainly in our annual meeting in January, but then also with the chief sustainability officers and a bunch of other chief executives. But the boardroom is equally, if not more important. So I'll be very brief. I just wanted to welcome everybody here to this beautiful premises. I think we're doing really well in attendance, by the way, Jen, especially considering there are a couple of events that you have to go through in order to get here. And a lot of the Deloitte colleagues are trying to get you into those rooms. So congratulations for making it all the way here. Maybe three things. So in 2019, the forum launched the so-called 8 principles for effective climate governance, and that in turn catalyzed the establishment of the Climate Governance Initiative. And it's great to see that today that network reaches over 70 countries worldwide. So the forum has been very intimately involved in CGI, and we will continue to do so. Evidence of that, and that's my second point, over the summer, we held an event in Geneva at our offices where we brought together non-executive and independent directors from more than 20 countries and 8 sectors for a day-long discussion about what it means to have climate as a top priority in the boardroom. And I think there's sort of a duality there that plays out. On the one hand, you have directors committed to make the company part of the solutions in driving the transition. That's a very positive sort of phenomenon. The second, of course, is that they're highly aware of all the risks that are related to the worsening climate crisis and environmental crisis. And our latest global risk report that the forum released in 2024, the 4 top risks for the next decade are all environmental in nature. And of course, to no surprise of people here, the other risks are also exacerbated by the environmental crisis. And then the last thing, just to say, before I hand over to Alexandra, we've also continued, or we have organized a couple of lunches with CGI and Deloitte. We did one in Melbourne, we did one in Mumbai, to really continue to work with directors on the issue of climate. And we will continue to do so here in the US as well in the next 12 months. So with that, Alexandra, I hand over to you, and thank you again for coming.
Hi, thank you. And thank you so much for all being here today. And as Rob says, battling through to get to here to the end. I'm Alexandra Bolton. I'm the director of the Climate Governance Initiative. And we ask a really simple question. What if every company had a climate goal and a plan to meet it? How different would the world be? So our clicker works. Okay. Maybe not. I'll keep talking. It's all right. So we cover every inhabited continent. We work in 73 countries. We have 32 chapters, and we work to support board directors, non-executive independent board directors and chairs, to have the tools that they need to be able to affect climate action in the boardroom. We know it's not easy, but if we can give them the tools, the knowledge and the skills, we hope to change the way things work in the boardroom. Our mission is to mobilize board directors to accelerate the transition to net zero and to build climate resilience. And I have 2 things I'm particularly excited to talk to you about today. One is the launch of our Directors Dialogue podcast. So we've been speaking to some fantastic transformational directors from India, from China, from the States, thank you very much, and from Brazil, who are telling us what they're doing in their boardrooms to make a difference, what that means, how that works. I'm going to give up. And so they can share their insights with you, so you can take that back to your networks. Oh, there we go. Thank you very much. The QR code that was up there, if you click on that, you'll be able to find it's hide and seek today. It's great fun. We have the podcast is available on all the major streaming places, so Amazon, YouTube, Spotify, you name it, it's probably there. But please scan, have a look, and listen to what these people have to say. I found it fascinating. And the next exciting thing is we're launching our ambassadors program today as well. We have 17, again, transformational experts and non-executive directors from around the world. It's a new global program that's designed to leverage the networks that these people have to support others to come on this journey with us to take action in the boardroom. As I say, we've appointed 17 who use their sort of leadership skills and their networks to expand the work that we're doing and to take action. There is our network where we are. If you have a look at us on social media by searching @Climate Governance Initiative on LinkedIn, you can find out more about the ambassador program, more about the podcast, and have a look at the ambassadors themselves and link up with them. The idea is to create a network of networks, so we have a much broader reach and therefore much better action. Thank you. I'm going to pass on to John, I think. Oh, to Lucy.
I don't have slides, which is great. So thank you. But just to sort of move on from the WEF to the Global Climate Governance Initiative, I'm Lucy Nottingham. I'm with the National Association of Corporate Directors here in the US, the NACD, and we're very pleased to be the US chapter of the CGI. And to that end, we are working to increase the climate fluency in the boardroom and providing directors and our 24,000 members with the tools and the insights they need for robust climate governance and oversight. So just for example, just today, very pleased to announce that we have put together, and it's available on our website, a climate governance toolkit that is based on those 8 principles, which is great. So I don't have to explain them. They're right there. and applying those principles in the context of the US boardroom in language and explanation that makes sense for directors. So we're very excited about that, and we're very pleased to work with content partners on that, including our host here, Deloitte. So that was great. So we're very pleased to have this session here today. I think it's just one of about, we've had at least 20 sessions on the topics of climate and sustainability just this year alone amongst our members. So we're very pleased to continue that dialogue today. So now I'm passing, I think, to Emily. Is there? Okay, well, I'll pass it over to Emily.
Okay, so we've got hide and seek, we've got pass the parcel. All good. Okay.
Attention, please, I have your attention, please. This is the fire safety director for 1221. Except we have received a waterfall alarm on the 50th floor of this building. Building personnel have checked this condition out, and we've determined that it is a false alarm. There is no purpose for return. All persons may return to their workstation at this time. Elevator service in A-Bank from the 39th to the 50th floor is currently in recall. We are working on getting this elevator system back in service. If you need to get out of the building at this time and you are between 39 and 50, please use the freight elevator banks to get out. Thank you for your cooperation, and we are sorry for any inconvenience.
Is it safe? Is it safe? Okay. Well, good morning, everyone. My name's Sarah Barker. I'm a managing director at Pollination Law, and I'm co-chair of the World Economic Forum's Climate Governance Community of Experts. And as is consistent in the climate field, there are no easy acronyms in our space. So I'm going to start this morning with a little bit of a confession, which I'm loath to make in a room full of heads of sustainability, which is that I don't care about the environment. I don't care about the environment. I don't care about the community. I'm a corporate lawyer. I'm a non-executive director. I'm a shareholder primatist. I care about money and I care about risk. And that is exactly why I care about climate change and why I know that, consistent with my duties as a non-executive director, that I have to give proactive consideration to the financial risks associated with climate change and the liability consequences that flow from it. So, having made that confession, I feel so much better. I'm going to start by actually taking you back in time. I'm going to take you back in time to what I'll call the Stone Age in climate governance years, which is 2015. Which you might remember was the year that Mark Carney, who was then governor of the Bank of England, gave his seminal Tragedy of the Horizon speech at Lloyd's of London. And this is looked upon as a very critical and pivotal intervention by a significant prudential regulator around the world. And the first time that we had the pillars of financial risk associated with climate change really broken down clearly. And you might recall this was the time where the Bank of England said, okay, we've got 3 buckets of financial risk associated with climate change. The first is physical risk, totally across that, impact of climate change on a natural and built environment. But then he spoke about a category that people weren't really accustomed to thinking about, which is transition risk associated with climate change. So the responses of markets to the risks and opportunities associated with climate change, whether it's policy and regulatory change, whether it's technological developments, whether it's shifts in the preferences of our stakeholders, like investors, like customers, like insurers, as presenting financial risks and opportunities associated with climate change. But then the secret sauce, my favourite pillar of risk associated with climate change, liability risks associated with climate change. And actually, I was honoured enough to write the liability chapter of the report that sat underneath this speech. And here was an identification of the fact that there are consequences of the failure to manage these financial risks and opportunities associated with climate change, whether they're physical or transitional. And they themselves are significant and material. And we're not talking here about compliance with environment and planning laws or emissions regulation. Because as climate change itself has evolved to be a financial risk and opportunity, it's opened up the entire book of commercial law to a failure to diligently manage those risks. So we've got exposures under securities fraud laws, consumer protection misleading disclosure laws, fiduciary duties, contract, tort, negligence and nuisance, human rights, the whole book. And as directors, we need to understand the financial risk consequences of failing to manage these financial risks. So that is the area on which I'm going to focus the balance of my comments today, on this, what is often an underappreciated, in my view, and focused upon pillar of financial risk associated with climate change, that being liability risk. Now, that leads to the threshold question. One that I often get asked is, why do boards need to think about this? Isn't this just a compliance thing that our general counsel and chief legal officers need to concern themselves with? Well, yes, absolutely. Your chief legal officers need to concern themselves about this. And believe you me, I understand that corporate lawyers, we are often last to the party to understand these risks through the forward-looking lens that they need to be understood. But why is it an issue that the board needs to think about? Well, it's very, very simple. Climate change is a financial risk. We know that. As Rob said, half, essentially, of the most likely and impactful risks to the global economy, according to the World Economic Forum. Climate change is a financial risk. Liability and litigation is a financial risk. Climate liability is a financial risk, a foreseeable financial risk. And it goes to the very heart of what our obligations are as directors to consider proactively foreseeable financial risks to our company. No matter which jurisdiction you're in, you break it down to first principles. What do directors have to do? We're in charge of strategy, risk oversight, and disclosure assurance. That's what we do. And we have to consider those things as we're stewarding the company in its best interests, to me, shareholder promises, best financial interests, with due care and diligence. We are duty bound to consider these issues. And often I'll get the pushback from directors to say, oh yeah, but Sarah, we're not an oil and gas company. These aren't material issues to us. To which my response is, these are evolving risks. How do you know they're not material if you haven't turned your mind to them? The other pushback I often get is, okay, Sarah, show me in the Securities and Exchange Act, show me where it says I have to think about climate change. To which my response is there anywhere in the Securities Act that talks about COVID or AI? No. These obligations are normative. They're built to require us to turn our minds to what is the risk environment that's evolving. We have a proactive obligation to consider these risks. So, understanding that these are risks that the board needs to consider, this is where I get to talk about the World Economic Forum's Climate Governance Community of Experts, which is a network of leading corporate governance professionals in climate governance and directors' duties that was convened by the World Economic Forum in July of last year from across legal practice, academia, policy and professional services. And our role has been to provide expert guidance to the Climate Governance Initiative on mechanisms that can be applied to leverage and amplify good corporate governance as a means to the end of the transition to the net zero economy. And in our year-long work program, we had 3 strategic priorities. And the first was to focus on board composition and skills and how to amplify capacity in boardrooms and making sure that we have the right set of skills on boards that enables boards to critically interrogate these issues. The second was in relation to sustainability and climate-related financial reporting and the role of boards in overseeing the significant uplift that is required within organisations at the moment to be able to both identify and translate into financial reporting terms the risks and opportunities associated with climate change. And the third, which is the one I'm focusing on today, a third work stream was on director liabilities and climate litigation for companies. And alongside Mike Berger over here from the Sabin Centre at Columbia, he and I co-chaired that work stream. That culminated on Friday with the release of our report for the forum and agenda article on the topic that we're talking about today. So the top 5, because everyone loves a list, top 5 climate-related liability issues that your board should consider. And in that agenda article, we basically stepped through what I've talked about today. The fact that climate change poses material risks and opportunities for companies of all kinds, which can trigger commercial liability exposures. The fact that there is an increasing focus on the standard of governance, on strategy and risk oversight. So boards and the directors that sit on them face an elevated climate liability related environment. So this is not just about climate related liability risks to companies, but also directors personally. And I think Sabrina on the panel is going to talk more about those. And so in that context, we identified 5 of the primary categories of climate related liability exposure that boards should concern themselves with. And the first is novel avenues of claim. And I've talked about this a little bit already, insofar as this is not just about compliance with hard emissions laws or environment and planning laws, and the fact that often companies are lulled into a false sense of security by the fact that they're not a coal, oil or gas company. And as I think Mike's going to talk about further in the panel, last year, for example, there were 230 claims filed against companies across a whole host of sectors around the world. Yes, coal, oil and gas, but also housing, agriculture, food and beverage manufacturers, financial services, banks, asset managers, for example. Professional services companies like McKinsey have climate-related claims filed against them, with causes of action ranging from breach of fiduciary duty directly against directors, securities fraud, shareholder derivative actions and stock drops, negligence, nuisance, contract-related claims. It's very, very broad. It's coming from very different angles. And again, if boards aren't proactively asking questions about this and turning their minds to, well, what is now our exposure on that holistic level? There's potentially a material financial risk that isn't being identified, that isn't being priced and isn't being managed. The second category, and I'm going to put this in the bucket of unknown unknowns, along with novel claims, because often this is an area that CLOs and boards just have no idea is a material exposure for them. And that is in relation to contract and the impact of climate change, where the future looks nothing like the past, on contractual obligations under material contracts, and in particular, where performance under those contracts is interrupted. I'm going to talk about that a little bit more, so I'll park it for a second. Third category, one of everyone's favourite topics, a known unknown, greenwashing, woohoo! So here, securities fraud and consumer protection, usually associated with targets and commitments, and where companies haven't aligned ambition with their actual practice on the ground. The fourth is another form of greenwashing, but this is a consumer protection context ordinarily, where there's misrepresentation in relation to the green credentials of a company. So whether that's in the context of enterprise branding or product labelling. And the last, which Sabrina will touch on, I think, further on the panel, is financial reporting. because whether it's under new laws associated with financial reporting and climate change, or just because of the increasing expectations that investors have about the way in which companies disclose financial risks and opportunities associated with climate change, there is a lot more pressure on boards to be diligently overseeing, well, how is the business actually going about uplifting our financial information and verification systems to be able to capture this information that we haven't previously captured in a way that allows us to disclose it in a way that presents a true and fair view. But in the few minutes that I have remaining, I do want to focus on these two issues as pretty core. But I would commend the agenda article to you for analysis of the full 5. And it also presents the questions that the boards should be asking in order to interrogate these issues. So the first is an unknown, as I say, in relation to contract. Now, with climate change, we know the future looks nothing like the past. And we know that the unprecedented is now often reasonably foreseeable. And that can have significant consequences when, in our material contracting practices, what do lawyers do to manage risks? We chuck a boilerplate force majeure clause up the back. So this boilerplate get out of jail free for unforeseeable acts of God clause. The trouble is, the envelope of what is now unforeseeable in terms of extreme weather events and climate impacts that can cause interruption to performance of contracts, pretty negligible. And so if we're still just chucking a boilerplate clause up the back, we are not managing those risks. And this can be a bet the company level of risk. So I know I need to get it out more, but Sarah's favourite case is a case called Stevens Ranch that happened here in New York, which was a force majeure climate change case relating to that once in a lifetime blizzard that hit Texas in February of 2021 when it snowed in Texas. So Stevens Ranch wind farm, 256 wind turbines. Spoiler alert, when they've got 6 inches of ice on them, they won't spin. So Stevens Ranch couldn't generate electricity during this blizzard. It had power supply agreements with Citi. So Citi, who had on-supply agreements to its customers, had to go out in the middle of a blizzard and buy alternative sources of generation supply, which cost them 3,000% more than what they would have paid under their contract with Stevens Ranch. So for 1 day's worth of generation, it cost them an extra $113 million US. So what did Citi do? As any good company, it called its lawyers and it sued Stevens Ranch and said, well, you owe us $113 million. You couldn't supply under the contract. That led to our loss. And Stevens Ranch said, oh no, once in a lifetime blizzard, force majeure, get out of jail free, unforeseeable act of God. And the court said, no. Just because it was unprecedented does not mean it was unforeseeable. And in fact, it was eminently foreseeable. We have been talking about climate change, the impact of both extreme hot and extreme cold for decades. There have been specific reports from FEMA on how both extreme hot and extreme cold could affect power generation in Texas. The blizzard did not cause your inability to supply. It was your failure to weatherize the turbines, which was a reasonable and proportionate response to this reasonably foreseeable event that caused the loss. Stevens Ranch was rendered bankrupt by that judgment. So if I'm a director on any board, I'm asking 2 very simple questions. First of all, and I have to look here because I can't look there. How have we updated our business as usual risk projections for product and supply chain interruption under climate norms and forward-looking scenarios? And this is in the agenda, so don't stress if you can't write it down fast enough. And the second is, how have we assessed our material contract risk exposures from force majeure clauses that are no longer fit for their protective purpose? How have we updated our approach in material contract negotiations? And the directors don't need to read the contracts themselves, but they need to ask questions. And what I'll finish on is the issue that is top of everyone's minds, which is greenwashing. And one of the primary greenwashing risks arises from what we call the say-do gap. So where companies talk a big game, big ambitions, but their actions on the ground do not align. Now, here, there is a real misunderstanding of liability exposure that often leads to greenwashing, and this is totally unfounded. It is not the case that if you set ambitious targets and that you do not reach those targets, that you'll be acting illegally. That is not what the law punishes. Where you will be liable is if you set targets and then you do not credibly pursue them. So your actions do not align with your commitments. So there've been a lot of cases on this. Recently, you might have seen that high-profile filing here in New York where the Attorney General Letitia James is taking action against JBS, the big meat company, including in relation to statements that the CEO made at Climate Week last year in relation to their commitment to reach net zero by 2040. This is a say-do gap case. So the allegation is, you say you got this target at reach net zero by 2040, you haven't even assessed what your emissions footprint is. So how do you know if you're going to be able to get there? You've also got strategies and plans to significantly increase production and no plan on how you're going to get to net zero. So there's that gap between what you say you're going to do and what you're actually doing in practice. Now, here, this can lead to this fear of greenwashing where companies say, well, unless I have a full roadmap about how I'm going to get to a target, then I can't say anything at all because I'm going to get slammed. Again, that is a total fallacy. What you do need to do is to be clear in your communications about, well, what are the assumptions and dependencies that impact on our ability to reach the target? Where are the uncertainties? Which parts do we know how to do? And where's the gap to target? And how are we going to work to get there? And disclose where we are on that journey. Are we at the start? Fine, disclose that we're at the start. So it's all about the disclosures and then making sure that what we do from an operationalization perspective aligns in terms of making sure that we're devoting the internal resources towards that. So Sarah also has a favourite set of climate targets, which is of a Greek shipping company called Stena Bulk. Now, Stena Bulk has a target to reach net zero absolute emissions across all scopes by 2030, including the cargo that they carry. Sorry, by 2050, including the cargo that they carry. And you might go, how the hell are they going to do that? And that's exactly what Stena Bulk says. We don't know how we're going to do that. This is a moonshot. But we know that it's a moonshot that we need to have. It's the North Star that every company needs to have. We don't know exactly how we're going to get all the way, but this is how we're going to start. We're going to start by 2025 by having our first demonstration hydrogen ship on the water. By 2028, we're going to have that 20% of our fleet, by blah, 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 blah. So they're setting the ambition and then they're being very, very clear about what they know, what they don't know, and how they're going to get there. So if I'm on a board, I'm asking these questions. How do we make sure that we're clearly communicating the material assumptions and dependencies and gaps to target when we're publishing our targets? Then how have we aligned our internal capability and capacity in order to credibly pursue the targets that we've set, including CapEx, including corporate strategy? And then have we also, linking back to contract, have we ensured that our targets are operationalized, particularly on scope 3, in the contracts that we have with our suppliers and our customers? Now, working with Deloitte and the Climate Governance Initiative and the World Economic Forum, they are singularly focused on strategy and opportunity. Now, I'm a corporate lawyer. I don't like opportunity. I do risk. And so the forum is constantly pushing me into, Sarah, how is this an opportunity? We're talking about opportunity. We're being positive here. How do you think about climate litigation as an opportunity, other than not being the one that gets sued? To me, it's all about understanding the parameters within which business can take place, being clear and not needing to be fearful because you understand the road that you need to travel and the path that you need to navigate. So to me, it's a bit like brakes on a car. Why do you have brakes on a car? It's not to slow down. It's to give you the confidence to be able to accelerate and to go fast around turns. And if you understand the evolution of these legal issues, you know where the mines are, it gives you the confidence to navigate around them. And that is really strategically empowering. So I'd commend the agenda article to you. If you'd like to do any further reading, there are all 3 agenda articles that have been produced by the community of experts on the World Economic Forum website. I'd also commend to you the primer on climate change directors' duties and disclosure obligations that has been published by the Climate Governance Initiative, and another publication that is currently being updated for release next week that I co-authored with Deloitte and the Climate Governance Initiative in Australia, which to our knowledge is still the only director-focused publication on what do the new mandatory reporting regimes mean around the world for directors. So look out for that over the next couple of days when the updated guide is published. Now, the final thing I'll say, because I'm Australian and we do love a drink, is that my colleague Jeff Summerhayes here, who is the chair of the Australian chapter of the Climate Governance Initiative, would like to extend the invitation to everyone in the Climate Governance Initiative to join us for drinks at Bryant Park Cafe between 6 and 8 any time this week, being hosted by Pollination. But for now, I think the pass the parcel is going to Emily.
Thank you so much, Sarah. We really appreciate it. And we just really appreciate the leadership co-chairing the expert community. You've just done such a fantastic job. I'm Emily Farnworth. I've had the pleasure of being with the Climate Governance Initiative since it started with the World Economic Forum, and the phenomenal job that the team has been doing and the work that Alexandra's been doing, particularly in the last year to grow this initiative, has just been phenomenal. So it's a pleasure to be here. I'm going to introduce now the panelists to come up. So Sabrina Bruno, who actually was one of the first chapters to set up. She was instrumental, the first chapter to set up. She was instrumental in co-founding Chapter Zero in Italy, a co-founder also of the initiative in the early days of being able to grow it. And so Sabrina, please do take a seat. I'd also like to invite Michael Berger up. You've heard already that he's going to be joining the panel. Shall I move this way? So Michael, who is the Executive Director of the Sabin Center for Climate Change Law here in Columbia, thank you so much for joining us. And also thank you for all the input you've provided for the expert community as well. And then finally, John O'Brien, none of this would have happened without you. Thank you so much for also joining the panel. It's wonderful. And John is now based here in the US as global lead for climate governance for Deloitte. And just thanks again for Deloitte to be able to host this wonderful event today. So I'm going to kick off. Sarah very kindly alluded to the fact that that Mike, you've been sort of very involved in this latest piece on climate litigation. It would be great just to kind of hear your thoughts and your sort of pick up on where Sarah left off in terms of some of the things that you've been looking at in terms of both the risk and the opportunity associated with climate litigation. So over to you, Mike.
Great. On. Okay. Well, good morning, and thanks for the opportunity to join this panel and this conversation. It was a real pleasure working with Sarah on this piece and over the last couple of years on the community of climate governance experts. One of the things we do at the Sabin Center for Climate Change Law is we track climate litigation globally. we maintain this database of climate cases. We have one batch for the United States and one batch for the rest of the world. The batch for the United States is an order of magnitude larger than the next largest single jurisdiction, which would be Australia. So in the US, we have something around 1,800 cases that have been filed, and in Australia, something around 180, and then it sort of goes down from there. But we have more than 2,500 cases all around the world that are focused on climate change. I do want to note that the types of cases that we include there, and so the scope that I'm talking about when I talk about climate litigation and the sorts of cases that give rise to the risk that Sarah was discussing, are cases where climate change is a material issue of law or fact in the case. What this means is that there's a vast universe of litigation that has direct implications for climate change, where the plaintiffs or petitioners are after climate goals that are not included in these databases because they don't explicitly invoke climate change. They talk about resources, they talk about energy, they talk about clean air, clean water, and toxics. They talk about land use. They talk about natural disaster, but they don't talk about climate change. So there is a much larger universe of litigation in which climate is central, and where climate risk, especially physical risk, is central, but are not included in this number. I want to talk about the number because I think it's just helpful to realize that we're talking about a rising number of cases, a increasing number of cases on a year-by-year basis since 2015. It's kind of leveled off. There was a big jump after the Paris Agreement, and things have sort of leveled off since then. Of these 2,500 plus cases globally, a relatively small number, somewhere around 150, are cases that involve securities and financial regulation in the United States, involve misleading advertising, involve disclosures, involve fiduciary duty, or things around those issues. But we're seeing an increasing number of those cases on a year-by-year basis. The big picture trend that I wanted to just note quickly is that, since Paris, we saw the jump in litigation, a good number of cases have been focused on ambition and the adequacy of corporate and governmental ambition. And a good number of cases in the last few years have turned from challenging just the ambition of the targets, the ambition of the goals, to whether there's a plan in place and whether there's a legitimate set of actions being undertaken to pursue implementation of that plan. So we are in this transition period where there's still a lot being done to set up set the targets and set the ambition, and an increasing number of cases that are meant to enforce implementation of those cases, of those ambitions. And that's as true when you're talking about the high media, high visibility cases like the Juliana case here in the United States, or the Urgenda case in the Netherlands, or the carbon majors litigation that's going after the fossil fuel industry, where you're talking about the cases that are really going for systemic change. It's also true on the individual types of cases that Sarah mentioned. The last thing I'll just say is that there is another sort of trend in the cases that's worth noting, which is not all cases are intended to enhance climate ambition. There is a significant undertow of climate cases that are meant to block it.
Yeah.
So I'll stop there.
Well, I mean, stop there, but it's also kind of an interesting point to kind of bring up. And I'll come on to Sabrina in terms of the sort of European reaction, what's happening in Europe, but just in terms of that sort of anti-ESG, or I guess there's lots of ways of framing it. Do you think this is a passing trend, or do you think this is here to stay? Is it going to get worse before it gets better? I mean, how do you see this evolving? I'm sorry to put you on the spot with that.
Of course, it's hard to say, right? But the backlash cases that I'm talking about, there are different sorts. One is the direct challenge to climate regulation. We see that a lot here in the United States, less so in Europe, but we do see it in other jurisdictions as well, where it's just an effort to challenge a government's climate regulation, climate policy, or some aspect of the functioning of its market in some way or another, its emissions market in some way or another. Then there's this kind of anti-ESG trend, which here in the United States is very politicized. And I would say that a good amount of the rhetoric around anti-ESG, is just that. It's political. There was a push to sort of challenge companies' participation in climate alliances as a violation of antitrust law. We at the Sabin Center did a deep dive into that, and there's just really no basis for it at all, at least in the U.S. and elsewhere. It's a very politicized environment, and that was something that was latched onto. But there's no there at the end of the day. We also are seeing sort of skirmishes in the courts right now around anti-ESG, and they're coming in both directions. There's cases that are seeking to force directors or force companies or force asset managers to take ambitious climate action under a notion that fiduciary duty requires that. At the same time, we're seeing cases where asset managers and fiduciaries are being sued because they do consider ESG factors. And the idea is that ESG factors consideration of that is a violation of fiduciary duty. I would say that there's no there either, but the litigation is happening. It's a very small number. We're talking about a handful or fewer of cases. I think that that's going to die away pretty soon. At some point in time, the one judge in the Northern District of Texas who takes these things seriously is going to be overridden by the weight of the law.
Yeah, interesting. I like the kind of there's no there. It's really appropriate. Sabrina, maybe I can come to you next. I mean, just from a European perspective, you've obviously been instrumental in the setup of this network and sort of thinking about how non-exec directors and independent directors are thinking about this topic all around the world. What are you seeing in Europe and your experience on your boards?
Right. So thank you for this opportunity. Well, in Europe, there is a legislation referring specifically on climate change, basically since 2014, requiring disclosure of climate risk related and also climate change opportunities. This original directive was replaced this year by the Corporate Sustainability Reporting Directive, which is in force since January this year. And that addresses, at the moment, biggest listed companies with 500, with more than 500 employees, but will address by the end of 2027 big companies, even if not listed, as well as small and medium-sized enterprises listed, with the exception of micro undertakings. So basically 50,000 companies in Italy will be addressed by the new directive, but plus 10,000 non-European companies. So this directive is important also for non-European companies because it will apply to branches of non-European companies that have a net turnover exceeding 40 million euros in Europe. Well, this new directive is very, very important. First of all, it's not, despite the name Corporate Sustainability Reporting Directive, it's not just a disclosure directive, because in addition to requiring disclosure of risks and opportunities, it requires companies to adopt an energy transition plan, which is aligned with the Paris Agreement, with the European target to reach net zero by 2050, and also requires companies to disclose greenhouse gas emission reduction targets expressed as absolute value, which means not considering any offsetting, which can be made, but I mean, it's not part of the overall reduction target. And also specifying that these emission reduction targets shall refer to scope 1, 2, and 3 emissions. And also the same directive requires that this energy transition plan shall have consequential financial plans, investment plans, I mean, it is important that the new document, the new sustainability document, shall be included in the management report, and there shall be it's called interconnectivity between information of the sustainability document and items of the financial statements, which is very important. There shall be coherence between climate change information and items in the financial statements in terms of capex, opex, and so on. Finally, companies shall also adopt mitigation and adaptation plans. This is important because, I mean, the distinction arises from whether the Paris Agreement target will be reached or not, since nobody knows what's going to be, what's going to happen with the temperature. The legislation requires companies to think in terms of both mitigation and adaptation plans. So aiming at reducing emissions, but also, I mean, investing in order to defend companies from, I mean, climate change, physical risks, or whatever. I mean, I want to stress, and I really liked Sarah's presentation, with whom I agree 100%. Because, I mean, the underlying rationale of European legislation is that climate change is a financial risk that can undermine financial stability. So all the legislation has been built in terms of risks and the opposite of risks that are opportunities, because you have to transform risks into opportunities. And this is very important. Of course, it's a big change for companies, but some of them have been preparing for this transition since 2015, 2016. Others have to adapt to this situation. And shall I mention the UK case now, or
Well,
what do you
maybe,
want?
I mean, in terms of, I know that we're going to lose all of those folks watching online shortly. So maybe I'll come back to that.
Okay.
Because I think it's actually really interesting to get into some of the weeds of that, and then there may be a chance for a few questions if we're not rushing anywhere. So let me come to John next. I mean, we've heard a lot of, you know, boards now have to take on the fact that we've got this changing context. The science is changing. How on earth do you keep on top of that? The law is changing rapidly, and the application of existing regulations is changing rapidly. What's your experience with the work that you've been doing with boards globally, and maybe perhaps most recently, since you have been working more in the US? How are boards responding to this? Are they kind of, you know, running scared? Are they getting their heads around it? Maybe you can give some insights.
Yeah, certainly, and great to be here. So it's kind of very interesting, and I think very different around the world. So it's depending a little bit on where it's starting from. So Europe, clearly, you know, very much regulatory driven. I think that the interesting thing for the Australians in the room, and there's I think 4 of us, maybe more. But actually the regulation is now coming in, but a lot of the stuff actually was started, there was very little regulation in Australia on specifically, there was obviously corporate law, but it was actually, a lot of the action was strategy driven in Australia to start with, because it's kind of, it didn't have the European regulation. So it was kind of that was a different frame, and sort of CEOs anyway were starting to push their boards from a strategy perspective as opposed to a regulatory perspective. I think that one of my worries in some ways is the emphasis on regulation and compliance and making sure your data is correct. There's huge amount of focus on that within the executive and then the board. Is actually taking the eye off strategy of the company, and you've got a perfectly compliant failing company, and it's just like, that's wonderful, we're not going to get sued, we are bankrupt, but we're not going to get sued. Isn't that good? So there is a difference there. And then in the US, I think there's 2 very clear categories for me in the US. So the multinationals, most of them because they're caught under the European legislation, and there's California legislation is sort of, you know, slowly edging forward. The SEC has stayed, but it you know, potentially comes forward again. But the multinationals are kind of in on this. They're in on the compliance side. The conversation, in my experience to date, is behind where it was in Australia and kind of where it is in Europe, in that the markets are changing. We need to change our strategy. So, but they're here on the compliance side. They're going, great, we need to do some compliance, and it's a good first step, because then you then start working out that, oh, actually, this is quite serious. But then the companies that are not multinational and just national, a lot of them are really very early in the US and really haven't turned their mind to this at all, and are not thinking it's going to impact them. until they realize that they sell to a multinational, and suddenly the multinational works out that they might need to do some scope 3 stuff, and so they will be caught. But there's a lot of companies that I think in the US, some of my conversations are surprising in that they're going, so this isn't a thing here, is it? So and you know, and then November, we don't talk about that, but then November might come and then it'll all go away. And it's so it's kind of interesting. And so the conversation I try to have is, it's kind of like, this is just business as usual. This is just a set, as Sarah was saying, this is just a set of risks, opportunities, and trade-offs. Just like, apparently, you know, health and safety wasn't a thing in the 80s. Cyber didn't exist in the noughties. You know, it's like, it's just a risk and an opportunity, and it's just business as usual. And one of the really important things is to change the nuance of words around that. Because if you start talking about it of it's good for the world, companies back off really quickly. If you say it's risks and opportunities, it's like, oh yeah, that's core business.
Yeah.
So change the language is the advice for the US firms.
Yeah, thank you so much, John. Maybe Sabrina, to come back to you on the Shell case, but perhaps with a slightly different angle on the detail of that. But to John's point, we're seeing this growing regulation and litigation, and we're seeing sort of the situation with Shell, but about this issue in terms of taking the eye off the strategy. I mean, what's your experience of boards, and what sort of, you know, how do you advise on kind of what your boards should be thinking about in the context of this backdrop of the kind of litigation risk, but at the same time recognizing the need to stay focused on that strategy?
Yeah, well, if a